Welcome to the New York Business Leaders Podcast, presented by the Coyle Group. We interview the most interesting and influential business leaders in New York and hear their stories of success, challenges, and lessons learned while building their businesses and personal brands. New episodes drop weekly, so please be sure to subscribe to get updates on your favorite stream. Without further delay, here's your host of the New York Business Leaders Podcast, Gordon Coyle.
Welcome back to the New York Business Leaders Podcast. I'm your host, Gordon Coyle. In this week's episode, my friend Sal Gangemi, who's an employment and labor attorney and a partner at Murtha Cullina, gives us some insights into the various employment laws employers of all sizes are facing today. First on the list of discussion points is the OSHA ETS initiative that was blocked by the Supreme Court about 2 weeks ago and what that means for employers. That conversation, of course, led us into a discussion around COVID rules and regulations for employers, and Sal gives some practical advice to follow, broadly speaking. For employers in the state of New York and the city of New York, there are just a host of new rules and regulations to look at for this new year of 2022. We also touch on wage and hour claims, discrimination claims, and much more. For employers who are looking to stay on top of employment law issues, Sal's firm publishes an Insight for Employers blog entitled Employment Law Perspectives, which can be found at murthaemploymentlaw.com, and I'll insert that link in the show notes. The bottom line is that employment law, especially for larger employers, is challenging, and as Sal indicates, the best strategy is education and prevention. The more you can do to prevent employment-based litigation, the better off you'll be, of course. Sal's contact is also going to be in the show notes. And finally, if you have comments, thoughts, or an interesting story that you'd like to tell, I'd love to hear from you. Drop me an email and let's set up some time to chat. My email is gordon@thecoilegroup.com, and you can find that in the show notes as well. Now, on to the show. Hey everyone, I'm Gordon Coyle. Welcome to the New York Business Leaders Podcast. Today I've got Sal Gangemi with me. Sal's an employment attorney. And I'm going to ask him to introduce himself, his firm, and what he does on a regular basis. Sal, take it away.
Sure. Thanks, Gordon. I'm glad to be here. My name is Sal Gangemi. I'm a labor and employment attorney with and a partner at Murtha Cullina. I work in the New York White Plains office and the Stamford, Connecticut office, and I address all employment issues for the management side primarily, from everything from employment discrimination to wage and hour and to this new sort of COVID type practice area, among other things.
So your area of the law is constantly changing, right?
It's unreal because I was talking to one of my partners yesterday who also does what I do. There's two of us at Murtha that handle employment law matters, and I said my practice is so different now than it was 2 years ago. And the reason it's so different is that I'm dealing with issues like COVID issues, which didn't exist 2 years ago, and I'm also dealing a lot more with OSHA than I was dealing with 2 years ago, because now OSHA is involved with these COVID issues, investigating a lot of companies and employers in terms of whatever safety protocols they have in place to combat COVID. So it's, and in the meantime, the other areas have sort of quieted down a bit. So for example, sexual harassment. I used to defend a lot of sexual harassment cases. But since COVID, people are not in the office. People are working remotely, so there's less. There's
no one around to harass anymore.
There's no one else around to harass, right? And I attribute it to that. That's not to say sexual harassment can't still happen. When you're working remotely and through Zoom and through texts and social media and things like that. But it really, really, really has come down, and so has everything else. Has changed. Wage and hour is still pretty much a big deal. The overtime stuff. It's still pretty much a big deal, especially in New York. Not as much in Connecticut, but in New York, it's a big deal. with restaurants and the hospitality industry. So yeah, so it's changed,
Always
and
changing.
this happens every few years. But honestly, when I say every few years, I mean maybe every 7 to 10 years. It doesn't just change on a dime like it did.
But COVID did that for everybody in every industry.
Yep.
Yep.
It upended everyone, right?
So who are your typical clients? Size, industry, those kinds of things.
So, although I'm industry agnostic, my firm represents a lot of healthcare, clients, a lot of long-term care facilities, skilled nursing facilities, assisted living facilities, hospitals, medical practices. So, with respect to the COVID stuff, I've been doing a lot of work with them. But aside from that, I work in the construction industries, the professional services industry, really any type of business that requires our service. And the sizes of these businesses vary. I mean, I would say most of my clients are around 100 employees,
Okay.
50 to 100 employees, but I've got clients with 10 employees, and I've got clients with thousands of employees. So it's all very different, and how I work with them really does depend on their size. For example, if you've got a small employer, and when I say small, I mean about 10 employees, many times they don't have a person on staff who's necessarily versed in how to handle some of the employment issues that come up. So I tend to be very, very involved on a day-to-day basis with those types of clients. And then the really, really large clients I'll get involved in, handling litigation for them, or advising them on a real novel issue, on a real strictly legal issue, as opposed to just counseling, quasi business legal. So,
Got it.
So that's how it works. Yeah.
Great.
Yeah.
So I wanted to kick off by asking about the Supreme Court smackdown of the OSHA COVID mandate rules.
Yes.
I'm sure that was a relief for a lot of your clients, employers, but it also probably created other questions like, does this mean employers can't mandate vaccines and all that kind of stuff? Do you want to spend a couple of minutes and comment on that?
Sure. So, I predicted, as did a lot of other lawyers, that it would be stricken, or that it would be blocked. I shouldn't say stricken, because theoretically it could still be, reinstated. Practically speaking, it won't, because an emergency. So this was the vaccine or testing emergency temporary standard, ETS. Okay. Right. Normally, when you've got huge programs like this, or huge mandates of some kind, they have to go through what they call a rulemaking process. But this was an emergency, so they didn't go through that process. But the trade-off is that they would expire. The ETS would, by its terms, expire after 6 months. Okay. And then they'd have to go through the process. So that's why I say, although the case, it theoretically could get reinstated, because practically speaking, there is a case that case is still ongoing. They didn't grant the injunction. They basically blocked it for the pendency of the litigation. But the fact of the matter is that nothing's going to happen in the next few months. This is going to expire around, I think it's probably May anyway. So that's out the window. Essentially, the decision really had nothing to do with whether mandating vaccines was the right thing to do. Okay. What it really had to do with was whether the president, the executive branch, had the authority through OSHA, which is an executive agency, a federal agency, to impose the vaccine mandate. Now, OSHA is focused solely on, its jurisdiction extends to workplace safety. Okay. The problem with the mandate, and the problem that the court saw with it is that the vaccine mandate really didn't relate so much to workplace safety as it did to just, the public health and safety. So, for example, there might be a rule that says you can't smoke in the workplace, okay? But when you go home, you could smoke. The thing with the vaccine is that once you got the vaccine, it was with you outside of the workplace. And really what it was the administration's way to get everybody vaccinated. So they did it this way because really it was the only way to do it, was, look, we'll just have the employers do it, right? Which, created a tremendous burden. The way it probably should have gone down, and this is something that the Supreme Court said, was Congress, our elected representatives, are the ones who are supposed to pass these laws because they reflect the will of the people. And if that's what the people want, the people in Congress should pass it. But, Congress is like, well, we don't want to be the bad guys, so they don't do anything. And then the president steps in to create this vacuum. And I will say this, I get the sense that the administration probably suspected that it would be stricken, but maybe thought, listen, it's probably going to be stricken, but before it's stricken, maybe we'll get a lot of companies to get their employees vaccinated. And then that could happen. The Supreme Court said, and I thought this was a big deal, if the mandate had been targeted to specific industries where there was an increased hazard or increased risk of imposing COVID, of contracting or spreading COVID-19, as opposed to a business where, for example, you're sitting at a desk, let's say there's no one around you, there's nothing unusual or particularly hazardous about that, then it probably would have been okay. So, for example, in healthcare, they that's a different situation. Agencies can mandate vaccines, and if OSHA had just focused on healthcare, let's say, it might not have been stricken. The mandate might not have been stricken.
And with regard to healthcare, the Supreme Court said that healthcare workers must be vaccinated, correct, through the OSHA mandate.
Well, it's not even through the OSHA mandate, so it's crazy because it's through a different agency, and the way they were able to get that done was not based on the reasoning that might have gotten it under the mandate that was stricken, but basically the government said anyone who is, and I'm paraphrasing, anyone who's treating a Medicaid recipient or Medicaid recipients must be vaccinated. And the Supreme Court said, yeah, they're allowed to place those, Medicaid can place those conditions.
Medicaid and Medicare. So any federally funded healthcare worker, right?
Yeah. Yep. Anyone who's and that's really every healthcare provider.
Right.
So the court said that's okay. Traditionally, that's been the deal. Whereas what OSHA was trying to do was just incredibly broad. And, I've compared it to, trying to swat a fly by dropping an anvil on it. There was a way to do it without it being so broad.
Yeah. The anvil reference just makes me think of the Roadrunner.
Well, that's what I think of too, and I think of Aardvark and Ant or whatever that.
And maybe we're showing our age with that reference, but
yeah, that's okay. Yeah. Right.
So, did you get like panicked calls from employers like, "Oh, what am I going to do? This is ridiculous. I can't do this."
Oh, you mean when they struck it down?
No, beforehand, when it was first being talked about.
So they were nervous, but it was earlier, like in the fall, I think it was. I can't believe I don't remember. It had been blocked by one of the circuit courts of appeals.
Right.
Nationwide, an injunction, a block on it, and then ultimately it made it up to the Supreme Court. So there was a period of time when it was blocked, and then right around the time it was supposed to go into effect, the block was vacated, and I can't remember specifically why. And so OSHA came out and said, okay, listen, we know we said January 10th is the deadline. That is the deadline for you to find out if your workforce is vaccinated. But we're not going to start enforcing the testing mandate until February 10th. So then, yes, people were scrambling. People were scrambling to get it done. And I'll tell you, the biggest burden, okay, one of the biggest burdens was the testing part of it. All right, because clients, before they'd come to work, they'd have to, once a week, they'd have to produce a negative test. Okay, well, how do they get you that negative test?
Right.
And one way to do it was to have the employer so the regulations provided kind of two options where, to make it quote unquote easier, have a telehealth provider sort of watch it being self-administered and then looking at the results, or having the employer do it. Now, having a telehealth provider do it would be expensive for a very, very large employer, incredibly expensive.
Yeah.
Right? If you think about it. And having the employer do it is kind of weird.
It also opens a whole can of worms for another can of worms for the employer.
Well, that's right. That's right. Because you're always then concerned that the employer, or let's say the supervisor, might start asking questions. Hey, why did you choose the testing? Say, you should have just gotten vaccinated. It's easier, and then you get into the whole, medical contraindications piece and my religion prohibits me piece. And then
I would also imagine there's a HIPAA compliance issue at hand there.
All kinds of privacy things. And, people were saying, Sal, can they do it by Zoom? I said, well, they say telehealth provider. Now, can the employer do it by Zoom? I said, as opposed to doing it in person? I said, that has to be okay, because they're not allowed to come to work anyway until they produce a negative test. Yeah. So how could they come down to work? I said, you know what? The regulation is quiet. I say you could do it on Zoom with the employer basically proctoring it that way. And that's what they were going to do. But employers were well within their rights under the mandate, and even now that the mandate is done, to say, look, we're not going to accept the testing part. You're either vaccinated or you're not, subject to religious and medical reasons. If you're subject to religious or medical reasons, we will accept testing results. All right. But a lot of companies didn't want to go that route. A lot of companies, like I have one client, they decided that for their office personnel and management, it was going to be required, the vaccine. But for the people who worked at their retail locations, their retail store locations, these people would be able to opt for a testing option. And they did that because a lot of the people who worked in the retail locations said that they were not going to get vaccinated. And the client didn't want to have to fire anyone.
Right.
Not only did they not want to fire these people, right? But it's hard. They didn't want to fire them because they didn't want to
find their replacements.
Finding the replacements is impossible.
Yep.
Impossible.
Yep.
So
the mandate is struck down, but it doesn't necessarily mean that an employer can't internally mandate on their own.
Employers could internally mandate it on their own. All right. However, some very large employers have recently announced that they're not going to do it anymore, that they're dropping it. I believe one of them was General Electric. I saw that early on. I think it was one of the first real big employer to say they were going to drop it. And now I think yesterday or this morning, Starbucks did the same thing. Starbucks did the same thing. It's one thing for an employer to have a vaccine mandate when everyone else is also subject to the mandate, right? Because an employee might think twice about leaving because the next
where am I going to go?
Where am I going to go? But
right.
now there are going to be options for employees. So in order to stay competitive with retaining employees, a lot of these larger companies have decided to basically just drop it. Drop it for now.
And that's kind of what, you heard from employers that were in that 100+ employee head count. They were like, my best drivers, my best workers, they're going to go work for a company that's got 25 employees that don't want to get vaccinated.
That's right. That's not fair. I mean, I get it. You know what? And this has nothing to do with whether you're pro-vax or anti-vax. Actually, I shouldn't say anti-vax, anti-COVID vax or pro-vax. The fact is, you really shouldn't be. The government shouldn't be requiring employers to shoulder that burden.
Yeah.
All right. Unless they can identify a real reason why it has to be the employer. Now, in healthcare, it's different. Okay. In healthcare, I get it. And in healthcare, they're not going to be these, employees who refuse to comply are not going to be able to work anywhere else, presumably.
Mm-hmm.
So there, I get it. And there appears to be a rational basis for saying, wait a minute, this is healthcare now. Okay. We need to go above and beyond here to make sure everyone is safe.
Right.
Whereas in a typical office situation, that risk isn't as pronounced or as obvious.
Yeah. Kind of continuing along with the COVID discussion, have you had many employers face any sort of litigation because of COVID or workers' compensation claims or things of that nature? Oh, I got sick at work. It's your fault. I'm suing you or whatever.
So no straight up lawsuits. Okay. Which I think would fail in most cases anyway.
Yep. Especially with the contagion today. God.
That's right. And it's also a workers' comp issue, assuming it happened at work. Now, that doesn't mean employers could sit back and say, hey, no masks, no nothing. No, you still have to take measures to protect people. And the real problem is still OSHA with respect to medical practices and long-term care facilities, because they are required, so they have there is a lot of requirements that apply to them that don't apply to just all general employers. So for example, let's say an employee gets very sick. Okay. Now, what the employee could then do and has done, and I've been involved in these claims, is report the employer to OSHA, and then OSHA sends somebody down, and then they start reviewing everything. And one of the things that in the healthcare field, most employers are required to have is what's called a written respiratory protection program that governs the use of respirators like N95 masks, right? The people have to be fit tested. It's not enough for a nursing home, for example, to give out N95s to everyone and say good luck. No, these people have to get fit tested. They have to be evaluated from a medical standpoint to make sure it's safe for them to wear the mask. Mm-hmm. So now a lot of these facilities never had written respiratory protection programs because they didn't really need them for the kind of work they did, the kind of stuff they did. Masks were worn obviously prior to all of this, depending on medical procedures that were being performed. But with those long-term care facilities that weren't performing medical procedures, they really weren't that familiar with what OSHA calls the respiratory protection standard. So yes, they'll come in, they'll start checking on the record keeping, and then they'll hit them with a fine.
Right.
Now, I will say this, earlier on, okay, it was hard to negotiate with OSHA to knock down the fines and the rating, this what they call serious rating. And the case would then go up to the Department of Labor's regional solicitor's office and would have to be litigated. But lately, I've had a little bit of an easier time getting these things resolved. And I think it's because the regional solicitor's office, which is the government's attorney, basically came back to the OSHA area offices and say, guys, you're killing us. Can you try to work this out? Can you please try to resolve this? I mean, what's going on here? Let's not get carried away.
Yeah. So I can just imagine. I mean, once OSHA's in the door.
And I hope nobody from OSHA is listening to this, and I don't have a problem with OSHA necessarily. Okay.
Oh, now you're covering your tracks.
I love OSHA. The problem is that, and I have to say they've been fair in terms of resolving these issues when they involve technical violations. But again, it's just another added burden to this. And And one more thing, you asked me about cases. I have had situations where employees have claimed that they were terminated because their religion prevented them from getting vaccinated, and the employer refused to accommodate them. But those are very tough cases to win if the employer is handling it the right way, handling requests for accommodation the right way.
It's very tough for the employee to win those cases if the
I
employer is handling it
I
correctly.
think so. And but they can win if the employer handles the process incorrectly.
Right.
And what do I mean by that? If the employer says, "What do you mean your religion? Get out of here," that's not a way to handle it. Oh, your religion, or even, oh, your religion prevents you from getting vaccinated. Okay, well, we're going to have to let you go. Bye. It doesn't. That's also a problem. The employer is required to what we call engage in an interactive dialogue with the employee, and I advise clients to do this in writing. Okay, so that there's no mistaking what happened. Okay, and so what the employer is supposed to do, and this is all shorthand, but the employer is basically supposed to say, "Oh, well, what can we do to make it easier?" Well, first of all, you have to substantiate what it is about your religion, or more correctly, your sincerely held religious belief that prevents you from getting vaccinated. Then can you identify what you think would work as an alternative? All right. And then the employer can review it and see whether or not it's a suitable accommodation request. And if it's not reasonable, or if it's going to be too much of an undue hardship for the employer could say, "Sorry, but we can't help you with this." And then they can terminate the employer. And under those situations, assuming it's done, like I said, it's done correctly, I think it's very hard for employees to claim, to succeed on one of those things.
Like on a wrongful termination suit.
Oh yeah. I mean, listen, I've helped some clients respond to reasonable accommodation requests, and I've advised clients, ask them this question, ask them a few more of these issues, right? Because when you get the request, it's like perfect, right? But you could tell they lifted it from the internet, because these things are floating around the internet, how to get out of getting vaccinated. Ask them this question, ask them that question. Let's see what they respond. You need more information, and you're entitled to request it. Then it comes back and you realize what their problem is. They're just pissed off that they have to get the vaccine. And then it becomes political. And that's not a basis. That's not a basis for rejecting the vaccine.
Right. Right. So that's what I was going to say earlier. So doing this in writing, either by email or by formal letter, really gives the employer the opportunity to speak with counsel, have you review what's going on in the background, and formulate a more perfect response.
That's right.
Okay.
So you don't need a lawyer like me to be reviewing it in the background, but a lot of clients who weren't sure how to handle it have asked me to do that. Larger clients probably won't need that unless they're completely unfamiliar with, HR, or aren't really strong in the HR field. But the important thing to have is, if you're going to mandate vaccines, have a written policy, and make sure the written policy talks about reasonable accommodations on the basis of religion and disability, like a medical contraindication.
Yeah, just don't walk in one day and put a Post-it note on the door and say everybody's got to get vaccinated. Mandate.
No, right. Says who? Says me. That's
the employer from the 1960s that's still around.
That's right.
So earlier you mentioned wage and hour claims still are an issue. Why don't we kind of define that, and who the typical employer is, and what those claims look like, and what they end up costing an employer, and then I'll give you a little of the insurance kind of side of it as well.
Got it. So most of the cases that we're seeing in recent years involve the hospitality industry. Okay. And the problem with what you're seeing is that some, and let's just say restaurants but it's not just restaurants, okay? Restaurants are doing things, are still in some instances continue to do things the old school way. The way the grandfather who owned the restaurant used to do things. I'll pay them a flat rate regardless of per day, regardless of the hours they work, right? And I'm not going to track their time. I know when they're here, right? And then the employee comes back and says, I worked 65 hours this week, or I worked 6 days, 12-hour days. I worked 72 hours and I was only paid $400 for the week. All right. That's a problem, because now in those situations, what happens is once the courts get involved or the Department of Labor gets involved, the first thing that's requested are the time records, the employer's time records. And a lot of times the employers don't have time records. And they're required to keep time records by law. They're required to keep time records so that when the Department of Labor comes in, they can see the time records, right? And in those situations, courts have said, listen, then the employee is entitled to prove that he or she worked 72 hours by whatever means necessary, okay? So that's why it becomes very difficult. So how does an employer defend against someone who claims they worked 72 hours when it's rational that they might have worked that many hours, right? The restaurant is open 12 hours a day, let's say, and doesn't have records to combat it, right? So in those situations, it's a real problem, because then you're going to have minimum wage violations and you're going to have overtime violations, right? And those cases have continued to flourish. And it's an even bigger problem now because restaurants aren't doing very well these days, right? Because of the pandemic. So it's an even bigger concern and an even bigger burden. And then you have the other types of overtime claims, wage and hour claims, where an employee is classified as being exempt from overtime requirements. Like, oh, well, that he or she is a manager, all right, they don't get overtime, and then maybe it turns out, well, yeah, their title is manager, but all they do is answer phones or do what someone tells them to do. They should be getting overtime for hours that they work over 40. So those are the types of cases, and those are still very, very strong.
And just to kind of clarify for the employer who underpays, you're not going to get an employee complaining about it. You're going to get an employee that complains and says, hey, my paycheck was short this week. But typically the claims arise when it's weeks, months and months and months of this behavior. Yes. And normally, I don't know if normally is the right term, but these often roll up into class action type suits, don't they?
That's right. That's right, because you might, and I can't believe I didn't say that while I was going on and on about restaurants, right? If it's one person, maybe you're talking about $30,000 liability, which, by the way, is still a lot, right? But even if it's $5,000, right? I've got clients who have hundreds of employees that have run into wage and hour problems, and I don't want to get into how it happened, because then I'll be giving away who the client is. But how it happened was, part of it was a mistake. What they were doing is they were paying the straight hourly wage for every hour worked. They weren't paying the time and a half. They were paying straight time. And the reason they did that was because they were getting reimbursed. I don't want to say from whom. They were getting reimbursed for the time these employees spent, but the reimbursement rate was below what the overtime rate would have been, right? So in those instances, you've got people owed $600, $1,000, $3,000, all right? 500 employees over a period that could go back 6 years. That's a lot of money.
Yeah. And then what are the potential fines and penalties that the Department of Labor assesses?
Yes, they will, and even in private cases that end up in court, the penalty is 100% of the amount that's owed. In other words, we're not just going to say to you, all right, pay us what you should have paid us, because then it's like, all right, I'm going to risk not paying these employees. What's the worst that could happen? That I have to pay them back with maybe with interest? I'm getting an interest-free loan. No, there's 100% penalties. So if I owe you $500, my penalty is I owe you $1,000. And there are fines also, and from the Department of Labor that add up. But it's that what we call liquidated damages, double damages. That's a real killer. Plus the employee's attorney's fees. Okay, so this encourages attorneys to represent people who might only have, like, even if it's an individual case, like where somebody's owed, let's say, $10,000, right? And it's a long, drawn-out case. At least the employer, the plaintiff's lawyer, will get paid in the end if they prevail. If by the employer. Now, if the plaintiff's lawyer doesn't have any basis for getting paid, why would that attorney? Why would he or she take that case?
Right.
$10,000. The most they're going to get, let's say, is a third, $3,300. So the law provides that sort of mechanism to allow the lawyer to get his or her reasonable hourly rate multiplied by the number of hours spent.
Yeah.
So,
and from the insurance perspective, if an employer has employment practice liability insurance, they may think, oh, it's covered. Well, it's not unless it's endorsed, and the endorsement only provides
attorney's
for the
fees,
defense, right? So if you still owe that $600,000 of back wages to your employees and another $600,000 to the Department of Labor, that's not covered by your insurance policy.
Right.
And
that
on top
makes
of
sense, doesn't it? Doesn't that make sense, though?
oh yeah, it would be against kind of
sense, don't you
public
think?
policy for the insurance company to be forking over these dollars. You committed a crime.
Payroll.
Basically. Exactly.
Right.
I found a way to get my payroll covered.
Yes, exactly. Right. Or do you find, Gordon, that your clients are surprised that something like this isn't covered?
Well, when we write employment practice, we always try to include wage and hour coverage, and it's sublimited. Usually you can only get about $250,000 of defense cost covered. And in the hospitality industry, it's very difficult to get. So it's sometimes not covered at all. So for the wage and hour claims, but we try to we try to get it included as we can. And if it's not, we certainly point it out because we see that as one of the most frequent claims under an EPLI policy.
Right. Especially now. Now, I know that there are instances where the carrier will say, look, the liability isn't covered. The attorney, we could cover attorney's fees, but you know what? Let's just pay X as liability, okay? Because we're going to end up spending the money on defense costs anyway, if not more.
Mm-hmm.
So I have seen that happen in those instances.
One of the other questions I wanted to ask you is not even in COVID times, it seems like there's always a rapid succession of legislation and new laws, regulations, and all kind of centered around employment that come out of New York City, New York State, the federal government.
Yeah.
How does the average small to medium-sized employer keep pace with all of that?
Well, in recent years, it's gotten absolutely crazy in New York in that way, because for years and years and years, and I don't mean that in a bad way that it's gotten crazy, but because some of these things were long overdue, some of these protections. But so for example, for years and years, when I started practicing, and for years, New York State's laws were very stagnant. They didn't change much. Right. New York City was always very, very progressive. OK. And then under the Governor Cuomo's administration, that sort of changed. And sometimes I used to tell my clients, I think the mayor of New York City and the governor of New York are arm wrestling to see who could be more progressive. Right. In terms of this legislation. So it does get to be tricky, especially if, let's say, you have a Connecticut employer with an office in Westchester County, New York, and one in New York City. Now they've got to be on top of these distinctions. Mm-hmm. And you've got to make sure you're complying with all of these laws, some of which might be in conflict with each other. So yes, it's very, very, very difficult. All right. And look, and I'm not saying this to drum up more work, but I do think it's important for them to have an employment lawyer take a look at their circumstances. Not, not a commercial litigation lawyer, not a divorce lawyer, not a criminal lawyer that they know. It should be an employment lawyer. I tell people all the time, I can represent you on an employment matter. Don't ask me to represent you if you get picked up for shoplifting, because you'll end up getting the death penalty with me. All right, because I won't know what I'm doing.
You stay in your lane.
Stay in your lane. Stay in your lane. Absolutely.
So, just kind of circling around that again, if you have an employer with multiple jurisdictions, is that an annual checkup with the employment attorney? Like, how does that go?
So what we try to do is we publish a lot of notices, we publish a lot of alerts to sort of that we just send out, so that if anybody has a question, they'll reach out. We try to let our clients know that something, that something is happening. Now, if we drafted, for example, the policies, all right, chances are we'll be on top of getting those policies changed. Okay, or letting them know. But if we haven't drafted the policy and we're working with a client that has policies already in place, it becomes a little more difficult. But what I do tell people to do is every couple of years, every 2 to 3 years, have someone take a look at your employee handbook and your employment policies. People are shocked when they see how many changes, how quickly changes can come. And right now, the big changes are in paid family and medical leave. And I'm talking from the standpoint of multi-statewide. These are big changes. New laws are kicking in as far as that goes. And sick time, earned sick time. Those are very, very big issues. And they've been big issues since even before COVID. They've just really heated up now in the last couple of years.
And if anybody's watching or listening to this show, is there like a newsletter sign up on your website they can go to get some of this info?
Well, yeah. So what I do is we have a blog that goes out. Okay. We have news alerts that go out, but our news alerts now, we've converted them. We've not converted them. We've been submitting them in addition to just sending them out to our clients. We're funneling them out through the blog as well.
Okay.
So if they go to our blog, which is employmentperspectives.com, all right, they can sign up, and we're pretty good. We're pretty active, and we try not to get too. I'm typing it up just to make sure that I got it right. Yeah. Wait, it didn't work. Hang on. Oh, no, I'm sorry. No, that's the name of our blog. It's Employment Perspective. So this is what you could do. Go to our website, murthalaw.com, or you can go to murthaemploymentlaw.com, and that will take you there. murthaemploymentlaw.com will take you to our thing. So just to give you an indication, on January 13th, the Supreme Court issued its decision blocking the mandate. Later that day, we already had a blog up. I mean, we had somebody, we were working on it, and we got it up there. And when I say we had somebody, one of our associates was working on it. My partner Trisha and I were working on it just to make sure that we could get it out there, to prevent people from panicking and asking, what do I do next?
Right.
So I think that's a good resource for people, and it doesn't cost them anything, really.
Yeah. So what I'm going to do is I'll put that in the show notes and in the description box in the YouTube. And while we're at it, why don't I jot down your email address if somebody wanted to get in touch with you directly?
Absolutely. So it's S as in Sam Gangemi, GANGE, M as in Mary I, at murthalaw.com.
Okay. Okay, so Sal, we're kind of running up some time here. I want to be respectful of your time. Any last comments that you'd like to kick into the conversation?
Just a general comment. We all know the expression, shoot first, ask questions later. Okay.
Yeah.
Don't shoot first when it comes to employment decisions. I have clients sometimes come to me, well, we did this, and this. All right. And now this is happening. Well, maybe you should have called me before you pulled the trigger, because you wouldn't be having to go through this, and this. So I think preventive counseling is the best way to avoid expensive lawsuits.
That's great advice. And I think that sometimes employers get a little heated when an employee doesn't do the right thing and they want to just pull that trigger, but it applies to a lot of things in life. Think about it.
That's right. No, and they end up shooting themselves in the foot.
Yeah. And those can be expensive bullets.
Oh, they could be. Insurance or no insurance, right?
Well, and even if you have insurance, the deductibles and retentions seem to be going up all over the place. So you're paying more out of pocket before the lawyer gets paid. Yep. Sal, it's been great having you on the show. Really appreciate the time you gave us today. A lot of fun.
Thank you. I had a great time. Thank you.
Great. So if you have an interesting story that you'd like to tell on this show, give me a call, drop me an email. My contact will also be in the show notes. I'd love to chat and see if we can't get you on the show. Until next time, thanks.
Thank you.
That's it for this week's episode of the New York Business Leaders Podcast. Be sure to subscribe so you don't miss next week's episode. In the meantime, find more interviews and resources at nybusinessleaders.com.